I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. I got a question for you. Theft, robbery, burglary. What's the difference? Do you know what the difference is between each one of these offenses? That's what we're going to talk about here today. Many times people get confused between what is the distinction between these and what does the law say has to be proven. We're going to cover that with you today, and if you'll wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's jump right into this. Now, when you begin to look at the subject just generally of theft crimes, okay, there's kind of an umbrella of several different criminal offenses in Texas that spring forth from that. Now, sometimes there's a lot of people that are confused about what's the difference between these three offenses. When you talk about theft, burglary, robbery, what's the difference? And if you're not sure, you're not alone. I see a lot of even news stories sometimes that I'll hear that people are confused about what the distinctions are and what the differences are, but it's very important because many times the difference between a theft and a robbery or a burglary can be the difference between a petty misdemeanor charge and a very serious felony charge that someone can go to prison for the rest of their life, potentially. So let's jump right into this for just a minute. In this video, I want to clarify the differences under Texas law. And the only way to do that is let's just jump into the most common one. The most common crime that we talk about is theft. Now, I do want to encourage you, if you go back to some of my other video series, look under the theft. I have a playlist for theft. You're going to go back and you look at that. You'll see that I do a breakdown about theft, what has to be proven, what some of the options are for diversion programs and different things like that. But if you go back and see that video series, you'll find that theft is generally defined as the unlawful taking of property of any kind from its owner and with the intent to deprive the owner of that property. Now, so in other words, if property is taken, if the owner did not give consent, or if they knowingly accept stolen property, you can, in that situation, be charged with theft. Now, penalties can range. It kind of ranges all over the place on theft because it's based on value. So if it's basically anything up to $2,500, you're talking about a misdemeanor. And then when you get above that, you start talking about felony level offenses. But it's based specifically on value. And theft charges can also apply as it relates to services and checks and different things like that. And they all fall under the same level of value that grades towards either a felony or a misdemeanor charge. Okay, so that's the simple one. Now let's talk about robbery. Now, robbery is a crime that basically is defined as something that takes place in the course of committing a theft, okay? So robbery is committed with the intent to obtain or maintain control of any property taken in the theft. And let's be clear about this. If in the process of attempting to steal something from someone else, if an individual causes bodily injury to another person, or if the individual places another person in fear of bodily injury or death while trying to steal from them, the individual must act. In doing so, they must act with knowledge, intent, or recklessness for the charge to apply. So, in other words, there's a very fine line between those two charges. Someone could walk up, and if they say they're in fear for their life because someone said, "Give me that, give it to me now," you could now be talking about something that's only worth $50, but if there's a threat that's involved in it or someone is actually physically moved or harmed in some way, it now moves up to a robbery. A robbery is a second-degree felony. So a theft charge might be a misdemeanor. Let's say it's $50. That would be a Class B misdemeanor, punishable by up to 180 days in jail and a $2,000 fine. But now, by grabbing someone and taking the same value item of $50, this now, if they're hurt or fear of being hurt, that now graduates this crime up to a second-degree felony, up to 20 years in prison, and up to a $10,000 fine. So you see there's a very big difference here between these two offenses. Okay, now let's talk about aggravated robbery. Aggravated robbery occurs when an individual causes serious bodily injury to another person or uses or exhibits a deadly weapon during the robbery. So this is a very big difference, okay? So now if someone is hurt very seriously as a result of those efforts, or a weapon is displayed and that person feels in fear for their life, you're now talking about a first-degree felony, minimum of 5 years, all the way up to life in prison. So let's talk for a moment about burglary. Just want to make a distinction between all of these. Burglary is an offense committed when an individual enters into a habitation or a building without the owner's consent and with the intent of committing theft, assault, or another felony. Now, I could get into the whole element of it entering for the purpose of committing an assault or another felony, but for the purpose of this video, we're talking about theft, okay, and how that ties in. So here is the distinction. People say, well, do you have to actually, to be charged with burglary, don't you have to actually steal something? No, you don't. If someone enters into that residence or enters into that building and the police can prove that there was an intent to steal, but you actually never get away with it, it's still a burglary. So big distinction there. So some people say, well, wait a minute, if you didn't steal anything, what if I didn't plan on stealing anything? What's the lesser charge? Do I have to take a burglary? No, the lesser charge to a burglary would be a trespass, a criminal trespass, being on someone's property that you were not supposed to be there. Okay, so it's really important to understand when you look at a burglary, if it's a burglary of a building, that is a state jail felony, punishable by up to 2 years in a state jail facility, and up to a $10,000 fine. If it's a burglary of a actual habitation, someone's home, that's a second-degree felony. That's punishable by up to 20 years, 2 to 20 years in prison, and up to a $10,000 fine. There are some small variables to this. There's a burglary of a coin-operated machine and a burglary of a vehicle. Those are both Class A misdemeanors. Once again, there's an element of an intent to steal. Someone's attempting to break into your car to steal something, to steal your iPhone or whatever is in there. They don't have to actually complete the act. They don't have to actually be successful in order for them to be charged. It's breaking in with the intent to do so. All right, now finally, here's where I get to the defenses. Let's talk for a minute about your defenses, okay? Now, many times, I'm going to give you an example. A robbery or a burglary charge can start out as a felony, okay? But many times with a good attorney working on the case and kind of really digging into the evidence, you may be able to find that it could be dropped down to a lesser charge, down to a misdemeanor. Now, one of the ways that can happen is people say, how does that work? The grand jury. That's where many times this can happen. Let me give you an example on that. You may have a felony robbery or a burglary charge drop down to a lesser charge because the grand jury, after your attorney has presented a packet to the grand jury of evidence, the grand jury may now believe, wait a minute, this charge is, the felony can't really be proven. It sounds like it's maybe more of just a regular theft. And I'm going to give you an example. We have represented a number of folks who were arrested for robbery, but it was really just what I call a capital shoplifting, right? An aggravated shoplifting. And what do we mean by that? As an illustration of this, we represented someone one time where they went into Walmart. They had taken a few items. On their way out, they made it out the front door of the Walmart, and they're walking over to their car, and a loss prevention officer chases them down. Well, they're running, right? The client's running. They're trying to run to get to their car. The loss prevention officer's chasing them, tackles them. They both fall down, and they're both hurt. Scraped up legs, knees. The loss prevention officer hits his head, and they charge our client with robbery because the police officer believes, look at this guy. This loss prevention officer looks like he got beat up pretty bad. And the reality of it is, though, is our client had no intention. He had no intent. There was no criminal intent to get into a fight with a loss prevention officer at Walmart in order to take a few items. And so in that situation, we were able to present a packet to the grand jury. The grand jury was able to see, wait a minute, there was no criminal intent here on a robbery. This really needs to be a lesser charge. And that robbery was dropped down to a theft charge, a misdemeanor theft charge. That's just one example. But my point is, whoever you make a decision on hiring as your attorney needs to be aggressive with the grand jury if you are being charged with a robbery or a burglary charge to give you a chance of being able to beat that charge, okay? So I hope you've enjoyed this video. That is just a small example of some of the defenses that may be available to you. I promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you have to do is click the link down below, and we will be happy to email that over to you. And if you like what you've heard here today, like the channel or like our video and subscribe to our YouTube channel, and we'll be happy to give you more great content just like this. Thanks again, and look forward to seeing you on our next video.